Hello, I'm Rob Clementi from Television Education Network. With me as a guest today is Tony Cahill, one of the great gurus of New South Wales conveyancing. Tony's going to talk to us today on the frustration of contract in the context of COVID, particularly in relation to readiness to issue a notice to complete. He's going to be talking about the DICO case. Tony, over to you.
Thanks for that, Rob. Well, I guess there have been many frustrations associated with the COVID pandemic, but one particular issue that has bedeviled property practitioners is whether a contract involving a sale or a lease of real estate could be affected by the doctrine of frustration. In theory, the High Court has said that such contracts are amenable to the doctrine. The difficulty has always been finding a factual situation where the doctrine actually comes into play. And that's well illustrated by the DICO Hotels litigation. That case involved a sale of a business and associated realty, an 8-figure sum involved for a pub in the outskirts of the inner city. The contract was the Law Society standard contract for sale of land, augmented by numerous special conditions, relevantly for our purposes, special conditions which required the business to be conducted in a legal way right up until the time of completion. A few days before completion was due, a public health order restricted the activities that could be carried out at the pub. And the purchaser, fearing that the value of the business had been diminished for an indefinite period of time, argued that they should be excused from the contract, amongst other things, because of the doctrine of frustration. At first instance, Justice Dark primarily focused on the operation of the doctrine of frustration and found that there had not been a sufficient impediment to the fundamental nature of the contract so as to enliven the doctrine. And on that basis, His Honour went on to find that the vendor was entitled to enforce the contract by way of a notice to complete and in due course termination of the contract. The purchaser appealed from that decision. Now, the applicability or non-applicability of the doctrine of frustration was not canvassed in the appeal at all. Nobody took exception to the analysis at first instance. Despite that, the Court of Appeal reversed the decision at first instance. And their key basis for doing so was a consideration of the special conditions about carrying on the business. Justice Stark had indicated that in his view, the restrictions on the way that the business could be carried out were not such as to disentitle the vendor from issuing a notice to complete. The Court of Appeal disagreed with that analysis, and bearing in mind that a notice to complete has to be issued only when a issuing party is ready, willing and able to proceed to completion, the Court of Appeal held that the issue of the notice was premature, that the reliance on the notice in order to terminate the contract was ill-founded, and that the purported termination of the contract by the vendor was in fact a repudiation, which the purchaser accepted, and that then entitled the purchaser to a return of their deposit and an escape from the contract. Whether the deal then went ahead subsequently, perhaps with a modified price, we don't know. But the DICO case does give a useful illustration not only of the operation of frustration in a COVID context, but also the circumstances in which one can properly issue and rely on a notice to complete.
Thank you, Tony. Of course, if you get the timing wrong or the nature wrong on the notice to complete, you end up repudiating, which is the point the Court of Appeal seems to have made. So we have to be very careful indeed.
Notices to complete can be a double-edged sword. They can sometimes hurt the issuer at least as much as the recipient.
Thank you very much for joining us, Tony, and we'll be talking to you again, I'm sure, very soon.